How to bring your child to the United States on a K-2 visa. That's what we're talking about on today's episode of Sumner School Family Immigration Basics. My name is Emily Sumner with Sumner Immigration Law. So if you are a foreign national planning to enter the United States on a K-1 visa for a fiancé of a US citizen, I have good news. You can bring your child. Your child can come with you using the K-2 visa classification. There are some requirements, namely the child has to be under the age of 21 and unmarried. The child has to be the biological or legally adopted child of the K-1 visa applicant. The general process is that you would list the child or children on the I-129F petition that you file with USCIS to start the K-1 visa application process. The child has to be listed on that petition, even if you're not sure if the child will come at the same time or later. The child has to be listed on that I-129F petition. Once the K-1 visa applicant applies for the K-1 visa, the child can apply for the K-2 visa either at the same time, or they can apply for the K-2 visa later through a process called following to join. They have to apply within a year of the K-1 visa being issued. When the foreign national enters the United States on the K-1, so the fiancé of the US citizen enters the United States on the K-1, the K-2 child or children can come with their parent to enter the United States on the K-1, child enters on the K-2. Like I said, it is possible for the child to come later. So keep in mind that it's not required that they come at the same time. It is possible to come later as long as it's done within a certain time frame. Once the parent, K-1 parent, is in the United States, as you know, they have to marry the petitioning US citizen within 90 days and then file the adjustment of status application for a green card. So depending on when the K-2 child enters the United States, they have to also file the adjustment of status application. It actually doesn't depend on when they enter, it just depends when you file, depends on when they enter. So they enter the United States and file. So it's two separate adjustment of status applications, one for the K-1 applicant and then one for the K-2 applicant as well. So what are some common mistakes that I see people make when they are looking to bring their child over to the United States on the K-2 visa? One is not listing the child on the I-129F at all. Sometimes people think, oh, that child's from a different relationship, or I don't plan for that child to come to the United States. If the child is not listed on the I-129F, they cannot come through the K-2 process, and it can cause other problems later as well. So make sure that the child is listed on the petition, on the I-129F petition. Another mistake is waiting too long to bring the child. That is not necessarily unfixable. It's not necessarily the end of the road. But if you wait too long to bring the child under the K-2 visa, you may have waited too long. If you wait longer than a year for the child to apply for the K-2 visa, a year beyond when the K-1 was issued, it's probably too late, and the visa shouldn't be issued in that particular situation. It may then be possible, depending on age and other factors, it may be possible for the US citizen parent to petition separately for the child, but that's a whole separate process. It's not part of the K-2 process. Another mistake that I see people make is having the child age out. So once the child turns 21, they're no longer eligible to come on the K-2 visa. I also recommend that the child submit the I-485, the adjustment of status, form I-485, the adjustment of status application in the US before they turn 21. So if you have a child or children who are going to turn 21 soon, you want to make sure you plan really well and carefully and know what the risks are, because your child may age out, and if they do, they would no longer be eligible for the K-2 visa. And then finally, forgetting to file the adjustment of status. So once your child enters the United States, unlike the front end of the process, with the front end of the process, you file just one I-129F and list the children. On the back end of the process, meaning once the foreign nationals enter the United States, you do have to file an adjustment of status for every person that is applying for a green card. So don't forget to file for the children, because they need their own separate green card applications in order to receive the green card. One final note, there is a difference in ages between this process, the K-1 process, and the process of a US citizen sponsoring a stepchild. So in this process, the K-2 process, like I said, the child of the K-1 visa applicant has to be under 21 years old, and they have to be unmarried. That is different. It can be more advantageous. I've had consulting situations before where I've been advising people on their options for immigrating to the United States through a loved one, a fiance or U.S. citizen spouse. And when they're not married yet, we've talked about the difference here, because if the child is between the ages of 18 and 21, they can enter on the K-2 as long as they're not 21 yet and apply for the green card, again, as long as they haven't turned 21. If the child is over 18, then and the parents are married, then that child could have a problem. They could already be aged out, because in order to create a parent-stepchild relationship, the marriage between the parents, the step-parent and the biological or adoptive parent, has to have occurred before the child turned 18. So just know that there is a difference between the process of a U.S. citizen step-parent petitioning for a child. That marriage has to have occurred before the child turned 18. And this process, where you have a little bit more leeway and the child actually can be just under 21, not the 18-year-old cutoff. So I hope that you have found this information helpful. If so, I hope you'll share this video with a family member or friend. Make sure you subscribe to our channel and turn the alerts on so you don't miss our next video. If you need help thinking through your case strategy about a K-2 visa, a K-1 visa, really any other type of employment-based or family-based immigration matter, we are here to help. We help people every single day walk through this process, walk by their side. We would love to help you next. There will be information on the outro slide about how to contact us to set up a consultation, which is the first step to take. Again, my name is Emily Sumner with Sumner Immigration Law. We work with clients from around the world and around the United States. Until next time.